All right, thank you all for coming. What I'm going to talk about today is neoliberal penality. It's a large project I'm working on, and it's got a few different facets to it, and I'm going to try and give you an overview of the project, and then maybe we can talk about different aspects of it during our questions and answer period. So I'd like to begin with two snapshots and a possible interpretation. What I would suggest would be a shared interpretation. The first is of a Parisian market in the 18th century. It's early May, 1739. Police Commissioner Emmanuel Nicolas Parisot is doing his rounds in the Marais market of St. Paul, going from baker to baker, weighing their bread, and he discovers 4 3-pound breads, each light 1.5 ounces. At the same time, another commissioner, Delespine, finds a cache of underweight breads in a small room hidden in the back of another baker in the Vieille Rue du Temple. This is what he might look like today, although it's more like what he looked like then. They seize the bread, and a few days later, the lieutenant de police holds court at the famous Châtelet de Paris, the palace of the police and of justice. And the bakers are sentenced to 50 livres in fines. A week later, the police lieutenant had convicted Marie-Hébert Héguin of buying grain at the market for resale. She'd bought grain with the intention of reselling it. She was fined 1,000 livres. In other cases, bakers were fined for buying grain outside of the market, for buying grain based only on samples that they saw at the market, or for speaking in a way that would raise the price of bread, or create a fear of scarcity. Now, it's in these terms that Fréminville, a writer of the period, described the Parisian markets in his Dictionnaire au traité de la police générale, which was published in 1759, in which he collected, assembled, organized, classified, reported, and reprinted all of the rules of the markets, all of the sentences he could find, all of the royal ordinances. It's a lengthy manual of policing, this dictionary, alphabetized by the kinds of interventions that the police are making. And it's really a compendium of disciplinary practices. Of his book, which is lengthy of 564 pages, there are 564 pages of rules and regulations that apply here. 90 of them concern the commerce in grain. So the regulation of markets, of bakers, of millers. It's about 1/6 of the book. And in fact, there are so many regulations of the market in this dictionary that when it came time for him to define markets in his dictionary, he simply decided to use a cross-reference. And so in his book, when you get to the entry for markets, he basically says, see police. Now, to our modern eyes, the Parisian markets, this police des grains, the policing of the grain, that intricate and extensive web of decrees and ordinances that governed every minute aspect of the commerce of grain, has come to symbolize excessive government control and intervention. The policing of the grain trade stands today as the example of minute government tinkering in the most atomic details of the commercial exchange. Even Foucault, who was a very subtle reader, would refer to the police des grains as la police disciplinaire des grains, right? The disciplinary police of grains. It came to mean discipline to us, and in contrast to our modern markets, viewed as being regulated through and through. Now, I'd like to fast forward to another time, another snapshot, and this is the Chicago Board of Trade. So we're in the wheat pits. It's March 20th, 1996. It's 12:01 p.m. The closing period for wheat futures has just come around. It spanned from 12 p.m. to 12:01 p.m. on March 20th. It had just expired. Wheat futures contracts were selling for $6 a pop. At 12:02 p.m., so 1 minute past close, Brian Scher, a local in the pit, offers to sell contracts at $7. And approximately 12 seconds later, at 12:02:12, he sells 31 contracts at $7 to Frey and Bedore, who'd been bidding up the price, hoping to close some open orders they had. Donald Scheck, another local in the pit, offers contracts at $7.50, and Brian Scher matches that offer. In the next half minute, Scheck sells 14 contracts to a broker named J. Ironimo, and Scher sells another 16 contracts to Frey and Ironimo, with final trades taking place at 12:02:50. 1 minute and 50 seconds past closing. Now, Rule 1007.00 of the Chicago Board of Trade provides that the Pit Committee, in this case it's called the Wheat Pit Committee, and it's chaired by J. Ironimo, who had just been trading in the post-closing seconds, that this Pit Committee could authorize a 1 minute extension and only 1 minute of the closing period, which would have taken us to 12:01, right? 12:01. Of course, that wouldn't have helped because a lot of the trades happen after 12:01, some of them happening at 12:02:50. So Ironimo, in his capacity, he's the chair of the Wheat Pit Committee. So he begins asking around to find out if any of the traders are interested in holding what's called a modified closing call, because there's a special rule, 1007.02, which allows for a modified 2-minute closing call trade period that spans 2 minutes if the Wheat Pit Committee members find some interest in the market. And if they do, this 2-minute post-closing trading session can occur, but it's got these very specific kind of amounts that you've got to trade at. So it's basically the range of 3 official trading increments, 1 increment above and below the settlement price. You've got 4 increments above and below the settlement price, as the Regulatory Complaint Committee prescribes. No new orders may be entered into the call, so you can't kind of jump into the market at this point. It's a highly kind of technical, regulated situation that basically allows for 2 more minutes of trading at a specific price. Brian Scher, who'd sold the last contracts past 12:02, he wants to trade. He expresses some interest, and so Ironimo decides that they're going to have an MCC. A bullhorn is used to announce the MCC, and they announce that it's going to be from 12:14 to 12:16 p.m., a few seconds before the start of the MCC. The exchange official announces that the MCC price would range between $5.30 and $5.32 per bushel. At that point, one of the traders for a corporation, Dreyfus Corporation, jumps in the market because $5.32 is a good price and buys a bunch of contracts. However, of course, he had not been trading before, so under the rules of the MCC, he was not allowed to jump into that particular MCC at that particular price. A bunch of people then close out some of their positions. Brian Scher and Donald Scheck, remember, they were selling at $7 and $7.50. They buy at $5.32. Which is the MCC price. They make a nice little profit, about $434,000, $152,000 for another one. Some people take a loss. Worst loss is about $300,000. Basically, the Office of Investigations and Audits of the Chicago Board of Trade then conducts a quick review of these March futures expirations. And about a month later, a separate entity called the Business Conduct Committee of the board issues charges against Scher, Scheck, Ironimo, Frey, Bedore, Kusep on behalf of Dreyfus, and a couple of other firms. They're charged with violations of Chicago Board Rules 1007.00, 350.05H, 1007.02, 425.02, and basically they're pursued. There are hearings, there in interviews, approximately 18 people are interviewed, taped, on sworn testimony, lengthy hearings to figure out that in fact they were trading post hours. They get sanctioned. There's review by the federal court that reviews these particular kind of transactions, sends it back to the committee because they hadn't imposed enough sanctions. Meanwhile, the U.S. Attorney's Office is getting involved and trying to regulate because there's a pattern and practice of trading post closing hours. And so everybody's getting involved, and finally it gets settled. and these folks have to pay some money and change their behavior. Now, more than 2 centuries separate the first episode, the Proceedings, from these enforcement proceedings at the Chicago Board of Trade. And the 2 periods have a number of similarities, of course, and a number of differences. But our perceptions of the 2 could not be more radically divergent. The Paris markets of the 18th century represent to us the epitome of excessive regulation, right? Of government intervention gone awry, of authoritarian control of the economy. In contrast, the Chicago Board of Trade reflects, to our modern eyes, the epitome of the free market. We don't see, when we look at the Chicago Board of Trade, and we look at what's going on there, and we look at the floor, we don't see Chicago Board Rules 1007, or 350.05H, or 425.02, or 107.02, right? We don't see all of the rules prescribing after-hours trading, MCC conventions, and hedging rules. What we see is the free market at work. How did that come about? How did it come about that we would look at one situation which has so much similarity with the Chicago Board of Trade and think, boy, that was overly regulated. That's what we call discipline today, right? And then look at the Chicago Board of Trade and think, well, that's the free market at work. What I'd like to suggest is that the answer to that question turns on the emergence in the 18th century of an idea, and it was the idea of natural order. There was an idea that emerged in the mid-18th century of an economic system that could be autonomous and that could achieve equilibrium without government intervention. Now, that idea of natural order, I argue, gradually and over the centuries evolved or metamorphized into our idea today of natural efficiency. The same idea in the 18th century that grew in about 1858, 1859, 1758, 1759, 1760. This idea of natural order is what ultimately becomes today an idea of natural efficiency in our markets. And it's what makes coherent or makes possible the belief in self-adjusting and self-sustaining markets. This is, I would argue, what facilitates our understanding today, made it possible. And I would argue it has had some terrible consequences in the area of crime and punishment. Now, the ideas were the product of kind of the early French economists, François Quesnay and the physiocrats. But it's important, before we get there, just to understand the background, right, and what they were writing against. Or one could say, what was dominant before? And what was dominant before was not a notion of natural orderliness, but a notion of a perfect overlap, in some sense, continuity of what you might call economy and society, or what you might call markets and the penal sphere. Okay? There was, in some sense, continuity and no separation between the idea of the market and the idea of punishing people. Okay? Now, the young Adam Smith understood this well. And in fact, what's really fascinating when you look at his early lectures and his early writings is that he used the notion of police to talk about economics. This is something that was familiar for someone who would have been working in the field of public economy in the late 17th, early 18th century. The field of political economy itself was located within what was called police. And so Adam Smith gave a series of lectures. These were his lectures on jurisprudence. It's kind of amazing to think that, right? I mean, these were his introductory law lectures, really. So, you know, he would have been standing here in front of you all giving his law lectures on jurisprudence. And they were delivered at Glasgow University during the period 1762 to 1764. Okay, so this was after the theory of moral sentiments, which was 1759, and before the Wealth of Nations, which was 1776. And he used the rubric of police to discuss public economy. So he identified the principal task of police as facilitating what was called, and he used the word, bon marché, a good market, an amply provided market with lots of subsistence, right? Lots of grains at a low price. And he identified the principal task of policing as making sure that markets were well-stocked and that the price of goods was reasonable. And so basically you can see this here. Jurisprudence, right? So these are his lectures on law. These are his lectures on law. Jurisprudence is the theory of the general principles of law and government. The four great objects of law are justice, police, revenue, and arms. Justice is civil foundations of government, right? So what we would think of today in terms of kind of part constitutional separation of powers, part civil procedure, okay? Establishing private property, essentially. Establishing and protecting private property. But the minute you've done that, and you've taken care of justice, you've taken care of getting rid of injuries and founding civil society, the next object is police. And the police is cheapness of commodities, okay? Public security and cleanliness, he says those two are too trivial for me to lecture about. So what I'm going to lecture about is cheapness of commodities, which is the opulence of a state, right? The wealth of a nation. And under this rubric of police, he then lectured about monopolies, about everything that we would consider today public economy, essentially. And he traced this notion of the police to French administration, citing the folklore of the King of France, who demanded three things of his lieutenant de police. First, the cleanliness and security of the nation, the cleanliness and the security, cleanliness, security, and then, of course, most importantly, abundance and cheapness of goods at market. And so it was the police's task to ensure that the markets were well supplied and regulated. Now, and the police, of course, at the time had a richer meaning than it does today, in the sense that today we generally think of police, we think of the uniformed police officer on the street arresting people, maintaining order, doing traffic. What police then had, I mean, it did have that sense, and it did have that meaning in the sense that the lieutenant de police was the police lieutenant who was in charge of all of this, and he had commissaire who would go through the markets and police the markets, but it also had a sense of administration. So the notion of policing was a notion of administration, and it's in that sense that there was a complete overlap between the policing and administration, right, of the economy, of the markets, and also the penal sphere, the result, the fines, at earlier times, you might be sent to the galleys, but at this point in time, in about the mid of the 18th century, it was mostly fines. Now, it would take a small step for someone to kind of think through the consequences of this perfect overlap, to then apply the discipline of the marketplace to the discipline of punishment, right? And that was Cesare Beccaria, the young Milanese aristocrat, who wrote a famous text in 1764 on crimes and punishment. Of course, the text is very famous today because of his abhorrence of brutal punishments, of the death penalty. This was one of the earliest tracts against the death penalty. Very influential in that sense. Influential on Jeremy Bentham, for instance, who was also opposed to the death penalty and who basically said, Cesare Beccaria has said it all, there's nothing more to say. The idea, of course, was right? Justice was not about cutting heads off, and that true justice would turn their head away from that. So that was the message that came out and that we all know today in terms of Beccaria. But what was important is that Beccaria himself was an economist. After he writes this, after he goes to Paris, he actually ends up returning to Milan, being appointed to a chair in public economy, one of the first 3 chairs in public economy in the 18th century, and then quitting, he didn't like academia, and going into civil service and being an economist for the Republic of Milan. But what's important is that he was a cameralist in his economics. He fit in the tradition of the kind of policing of the economy that goes with kind of that we consider today disciplinary. And his intervention in this book actually is best understood as the application of economic logics of discipline to punishment practices. Right? And what he was trying to suggest, in fact, is that our punishment practices are arbitrary, random, brutal, and demeaning, and barbarous. And the real problem is that we haven't applied what we know about commerce to punishment. And what we know about commerce is that if you regulate it well, it will be rational, there will be liberty, and there will be proportionality. And so he says, he writes in the introduction to this book, "We have discovered the true relations between sovereign and subjects, and there is waged among nations a silent war by trade, which is the most humane sort of war and more worthy of reasonable men." In other words, we have come to understand how to regulate markets. We have come to understand that regulated exchange, is the best kind of competition between people, between sovereigns and subjects. And what we need to do now is apply the same logic to tame our punishment practices, and in the process eliminate the brutal excesses of the 17th century. Now, if cheapness, if bon marché was the kind of basis of that earlier period, bon marché created through a regulatory system, it was really the antithesis to what came afterwards, which was the French economists, the first French economists in 1757, and the physiocratic movement in France, and the British liberal economists and the Wealth of Nations in 1776. So, and you could see the kind of the real contrast to the Beckerian, to the early Smith view of bon marché right here. This was one of his famous maxims, right? Abundance and plenty. Abundance and plenty do not translate into the wealth of nations. Scarcity and high prices, of course, are misery. It is abundance and high prices that produces opulence. And so François Quesnay developed a school of thought which basically changed the way we thought about pricing, changed the way we thought about the regulation of markets, and instituted a very different tradition of thinking about the market as a self-regulated, kind of autonomous sphere, right, that could be divorced then from the penal sphere, that could be divorced from punishment. Now, at the heart of Quesnay's work was this famous Tableau économique. It was first published in 1760. It was published in Mirabeau's book, The Friend of Man. And this tableau was a graphic depiction of the cash and commodity transfers between the 3 principal classes in society. A number of economists have spent their lives trying to understand this and have unanimously concluded that it doesn't make sense. So don't kill yourselves. But the idea essentially was that there were 3 classes in society. The first is the agricultural producers, the people who actually produce goods on the land. The second are those who own the land. And the third are the sterile people who produce goods and commerce. All right, and you probably have. How many of you have heard of Keynes? Few, very few. The reason you haven't heard of Keynes is because in 1760 he declared, and his position was that agriculture was the principal productive force in economics, right? Right before the Industrial Revolution, right? So basically, he's kind of been forgotten, particularly in the Anglo-Saxon world, in part because he called commerce, industry, manufacture, factories, the future, sterile. Okay? All right, so that's what it was. These were the dépenses stériles, and this was the classe stérile. So anyone who was a merchant was a sterile class. Not, you know. So anyway, okay, so but put that aside for a minute, right? And put aside the fact that he thought that agriculture was so important. The central insight, which then kind of shaped the rest of the 18th century and the 19th century, and I would say shapes us today, is this idea that it is an autonomous system, right? It's an economic system. There's no intervention. That was the whole point of this graph. Doesn't make sense, but you end up with a surplus at the end that then goes back in, and you've got an economy that's growing without any government intervention, without any government regulation, without any taxes, without anybody doing anything to this autonomous system, right? And the notion is autonomy here. Systems are not always autonomous. An engine is a system, but you have to put gas in, right? Here, the idea was you don't have to put anything into this system. It works. And this idea that it works, this idea, which was founded on a notion of natural order, for Keynes and his collaborators in his sect, it was a religiously infused notion of natural order. It was a divine natural order. But again, we can get rid of God too. We can get rid of agriculture and we can get rid of God. And what we're left with, right, is a notion of natural orderliness that makes the system work without any intervention. Okay. Now, it's this same notion of natural orderliness that resurfaces later in the work of Adam Smith. I mean, one of the remarkable facts is that when you look at the Wealth of Nations, which comes out in 1776, so 14 years after he had given the Glasgow lectures, right, there is not a mention of police. I think the term is used twice. I found it so far. I found it only twice in the text, right? But in other words, the Wealth of Nations is the entire treatment of economics that he had done in 1762 under a police rubric, and that now is kind of unleashed, unmoored, severed from that whole notion of policing and developed on its own in an autonomous way. And you see it also, of course, in Jeremy Bentham, who was highly influenced by Adam Smith's economics. And today, I would argue, in the work of contemporary neoliberal thinkers. Jeremy Bentham in all of this, of course, is probably the most fascinating character, because what he did was he took the economics from Smith and the punishment from Beccaria and put it together, right? In a way that you'll see, in a fascinating way, that actually replicates kind of what Keynes did. But we came to the point that today, right, we no longer believe in a seamless continuity between the economy and policing, right? So post-Smith, post-Bentham, and now with our more neoliberal approaches to markets, we view markets as being, in some sense, separated from the penal sphere. Now, what I try to argue in this project is that that has had two devastating consequences. And it has come at the price, first, of significantly distorting and expanding our penal sphere in this country. And second, in naturalizing and then hiding the regulatory mechanisms in our own contemporary markets. And by hiding those mechanisms, we then don't see all of the distribution and redistribution that we do. Right? It masks the distribution, naturalizes the distributional consequences, and means that we think that kind of the Chicago Board of Trade outcome, right, an outcome from an unregulated, allegedly, market, is natural based on merit and should not be questioned. Okay? Now, let's talk first about the distortion of the penal sphere. What I argue is that the emergence and gradual dominance of this idea of natural order has created what I call neoliberal penality. And by neoliberal penality, I have in mind a form of rationality that we tend to adopt, that we tend to believe in, for a way of thinking in which we push outside political economy the penal sphere, and we use it as a barricade, a barrier. A barrier, it's marked off from the dominant logic of neoclassical economics as the only space where order can be enforced by the government. Right? And so my argument is that this discourse of neoliberal penality has facilitated the growth of the penal sphere because it makes it easier to resist government intervention in the marketplace and to embrace criminalizing everything else or everything outside of the marketplace. It facilitates passing new criminal statutes. There's no resistance to criminal statutes because that's where the government should intervene, right? That's the place. That's the place where administration is necessary. That's where the state can legitimately act, and that's the proper sphere for governing. There and there alone, right? Now, I think that this is captured, and for my students, we were talking about this this week. I think this is captured well in Richard Posner's very succinct statement of the role of the criminal law. Our colleague, Dick Posner, has a great habit of being very blunt and simple about things, and I think that it does a service to be so explicit. What he writes is that the major function of criminal law in a capitalist society is to prevent people from bypassing the system of voluntary compensated exchange, the market, explicit or implicit, in situations where, because transaction costs are low, the market is a more efficient method of allocating resources than forced exchange. When transaction costs are low, the market is virtually by definition the most efficient method of allocating resources. This is the assumption of natural order, right? This is Keynes' assumption of natural order. It's Smith's notion. It's the modern way we talk about natural order is through natural efficiency. Attempts to bypass the market will therefore be discouraged by a legal system bent on promoting efficiency. Now, and so the idea here, what this passage leads us to is this vision of the world, this understanding of the world where there's a core system that is regulated by natural order, which goes to equilibrium by itself, barricaded by the penal sphere, which is used to keep us in the middle of the donut, right? And in fact, natural efficiency is so central to Richard Posner's thought that he actually defines criminal behavior as inefficient behavior, right? So he says, I argue that what is forbidden, i.e. criminalized, is a class of inefficient acts, right? So you have to understand that it's not only not only normative, it's a positive description of actually what our criminal law is. Criminal law is the donut around the economy, which is constituted by inefficient acts. Okay, we can go more into that, but it assumes that everything is a market transaction, but that and that anytime you escape from the market transaction, you're engaged in inefficient behavior. Now, what I'd like to suggest is that this idea actually traces then to early liberal thought, and that it was actually embedded in early liberal thought, embedded actually in the thought of the physiocrats. And even though there isn't much intellectual transfer from, well, there was a lot of exchange, but a lot of resistance in the intellectual transfer between the French and the early British liberals. Nevertheless, the French theorists of the period had an idea that they called legal despotism, and that they embraced. Quesnay and Le Mercier de la Rivière embraced this notion of legal despotism, and that developed into their political theory. That was essentially their political theory. And what was the idea of legal despotism? The idea of legal despotism is actually that the despotism is the rule of natural law and natural order, right? And what it entails is that we do not need to have positive laws for the most part. Why do we not need positive laws? Because the natural laws operate, right? And so their argument basically was it would be foolish to create positive man-made laws when in fact it's natural law that governs, and all that we could do with positive law would take away from the orderliness of natural law. It was a bit of a syllogistic reasoning. I mean, basically it started with the idea that the economic realm is governed by fundamental natural laws that promote the best interests of mankind. That positive man-made laws can only mirror those natural laws, right? And therefore, we need to try and avoid positive law as much as possible. In fact, he said, positive legislation should therefore not reach the domain of physical laws. Positive legislation should not reach the domain of natural law. Okay? Therefore, you don't need a legislature, turns out, because if you're not going to have positive law, you don't need a legislature. Therefore, all power can be reunited in the monarch, who is enlightened, educated, and can see what the natural laws are. And so you have absolute hereditary, unified executive power, but in the monarch, and except for the fact that there are some people who are disordered, who don't see the orderliness out there, who don't understand that there's natural law. And for those people, who Quesnay calls the déréglés, so the deregulated, the unregulated, right? For the déréglés, there, we need to have a little bit of positive law, and what it is a severe criminal code, okay? And so you have a severe criminal code for what he called les voleurs et les méchants, for the thieves and the mean people, the thieves and the derelicts, okay? And for them, of course, we have positive law, we have the penal sphere, we have criminal sanctions, and we can go at it pretty robustly because they are not seeing the natural orderliness that surrounds them. He published this in this tract called Le Despotisme de la Chine, the Despotism of China. It was published in the Éphéméride, which was their journal. It was their University of Chicago Law Review. And basically, what he did was he and then Le Mercier embraced this notion of legal despotism. And my point is that you can see that the same notion of natural orderliness that is in the early French economic thinking gives way to a kind of vision of legal despotism very much in the same way that natural efficiency, right, in today's contemporary neoliberal vision gives way to a very robust and large penal sphere. You might have noticed a New York Times article about a month back under the header, Prison Sentencing Outpaces All But Medicaid. So according to the Pew Center on States, criminal correction spending has outpaced budget growth in education, transportation, public assistance. I don't need to go into the size of our carceral sphere. As you know, we incarcerate 1 out of 100 people in this country today. 1% of our population is incarcerated, which is one could say, a staggering rate of incarceration, particularly in contrast to other Western and other civilized or other, no, not civilized, other Western industrialized countries. All right. So that's the first prong. It's in some sense how the notion of natural order facilitates a neoliberal penality. It facilitates the increase of the penal sphere. The second the second consequence is that it naturalizes the market and hides the massive redistribution that takes place there. So it masks the state's role, right? It masks the state's ties to non-state associations, associations such as the Chicago Board of Trade. The Chicago Board of Trade is a quasi-public organization. It's actually a private organization. It was chartered in the 19th century as a private group for the brokers who were trading that acquired monopoly power over the trading in grain and other commodities and futures, et cetera, eventually. But that itself has extensive legal regulatory frameworks, self-regulatory frameworks in part, but also state regulatory frameworks. It's an embeddedness of non-state, state, prosecutorial, et cetera, rules that governs the Chicago Board of Trade. Now, and what's fascinating to a certain extent is that we not only is the regulation today masked, but to a certain extent the discipline of the 18th century is exaggerated. And so this notion of natural order, on the one hand, hides all of the regulation that takes place in the free market, but it also hides all of the liberty that there was in the French Parisian markets of the 18th century. So if you actually go to the files in Paris at the Archives Nationales to look at these police files and to see what was going on, what's fascinating is that when you actually look at what the commissioners used to file reports on what they did each day. I was just struck and fascinated to see that basically the principal violation that they seemed to be enforcing was the fact that people didn't sweep in front of their stores or homes. Okay? So this is the listing of one of the commissaires for one particular day of the violations that he found policing the French markets. And what does he find? He finds here, non balayé. Balayé is to sweep, okay? Non balayé. So the guy hadn't swept his front. Non balayé. Non balayé. Non balayé. Non balayé. Non balayé. This is the Cabaret. It's a nice place, I suppose. Cabaret on the Merle Blanc. That sounds fun. Non balayé. Right? This one is the, I don't know, which one is this one? Le devant de la cabane non balayé. Right? Mouffetard, Rue Mouffetard. I don't know if you've been there. It's a beautiful market. Well, non balayé. Okay? I mean, so when you actually look at what the policing consisted of, right, you have this very different appreciation of what all this policing was about, right? And it turns out that actually the ordinances, the ordinances that Fréminville himself was a free marketer, and the tract in some sense is a tract against policing. And the sentences that he found, he really had to dig hard to find a few of these fines. It turns out, and to a certain extent, the police lieutenant was actually kind of a minor figure. It was a civil position. It wasn't the criminal position. There was a separate criminal court with a lieutenant in charge of criminal affairs. And basically, if you really dig into it, you get a sense that, these were tiny, trivial little issues they were dealing with, involving tiny, trivial little fines for tiny, trivial little things, right? It turns out that there was actually a lot more freedom in that space than we tend to recognize today. So what I would argue is that that it's the problem that leads to this kind of dichotomous view of kind of discipline and free markets is precisely the categories themselves. It's precisely the categories of the free market and the category of regulation. We have come to adopt these as heuristic devices to, in some sense, make facile, quick judgments about different forms of market organization today. so that we can label one quickly free and the other regulated and then take a position on it. When in fact, market structures, market organization are inherently individual means of distributing resources, of arranging market transactions, and that those labels, free market and regulated, in fact, get in our way, right, in terms of evaluating the regulatory mechanisms that are in place. And so what I argue in this work is that the fundamental problem, the hitch, is that those categories of natural order, market efficiency, or free market, or on the other hand, excessive regulation, government inefficiency, and discipline, are misleading categories that fail to capture the irreducible individual phenomena of different forms of market organization. In all markets, the state is present. In all markets, there are regulation mechanisms that regulate, exchange, and distribute wealth. It's true in the Chicago Board of Trade, whether you allow a futures and options or not, which were not allowed, which became allowed, how you determine what the contract says about where you store your wheat. It has to be in Chicago. That's going to have a distributional effect on farmers who are further away. All of the rules, even the rules of an ordinary boilerplate contract, have distributional consequences and are, in fact, regulations of exchange, right, that get hidden when we simply talk about freedom versus regulation. And so when we say that, this one site is a place of free market or this one site is a place of discipline, I think it's reflecting more about us than it's saying anything about the market itself or the object that we are talking about. And those terms, they might be useful in a course. They might be useful as a way to categorize different. They might be heuristically useful when we want to try to teach something, but they're not at all useful when we want to try and understand what are actually the distributional consequences involved. They are not useful when we try to evaluate different market mechanisms. And so what I argue is that we need to completely abandon those terms. Now, this work obviously is just a beginning, but it's a necessary first step in the direction of properly assessing modern forms of social and economic organization. And I say necessary because of the dominant and somewhat deafening discourse about natural order, about natural efficiency, about market efficiency. The very idea that we would use free in this context, right, which in some sense is a term, or liberty, that comes from another context, a political context, but somehow to import it into the economic domain is really a testament to the work that needs to be done to kind of expunge it from our vocabulary. But that is, I argue, what we need to do, and that at the same time, I hope would help us dismantle our extended penal state. So why don't I stop there and take your questions. Yes?
I'm an economics student. I'm glad you're like the first person that I've heard speak to not like I'm for regulation, I'm against it. So thank you for that.
Okay, good.
I wanted to ask you, how do you feel about the role of academia and your touch with like that usage of language? Like, I feel like
academia is the worst. No, it's predominantly an academic effect, I think. Yeah. I mean, I think that you are at the eye of the free market, right? And so to a certain extent, I think that the notions of free market are perpetuated and used toward political ends, and also towards marketing ends. So I mean, it's not a surprise that we're going to have we have a Milton Friedman Institute here, right? Because Milton Friedman's name brings money, right? Millions, and so I think that it's the perpetuation of the use of the term serves instrumental purposes that unfortunately I think are at odds with our overall interests, right? But yeah, it's definitely the case that people are clinging to those terms, and tragically, I would say, on both sides of the debate right now, right? Because people, in my opinion, people who argue what we need is more regulation, that's a meaningless argument to me. To me, that makes no sense. It doesn't tell me anything, right? Everything is regulated. The question is, what kind of regulation are you proposing? It's not more or less, right? It's not free or regulated. It's tell me exactly what you are talking about in terms of the regulatory mechanism so that I can try and figure out how it is going to allocate resources and redistribute wealth. And then I can tell you whether or not I think it's a good idea, right? But to use those terms or to simply argue that, we need less or we need more is, in my opinion, a big mistake. And I think it's been fueled tragically by many academics. Yeah. Yeah.
So what do you see in terms of the role of the antitrust laws in this argument?
Okay, so the antitrust laws are huge regulatory mechanisms, right? And people who deal daily in antitrust, I think, would be the most receptive to my argument, right? I mean, it's the law regulators, it's the people who have their hands deep in our regulatory mechanisms who are the ones who are least likely to think that there's a free zone and a regulated zone, right? And that is a central regulatory mechanism. Go ahead.
Because when Smith, at the time of Smith wrote before it was clear that there were economies of scale.
Well, but his writings were clearly, I mean, he clearly addresses notions of monopolistic power and is clearly opposed to it and sees a significant role for government intervention in eliminating monopolies. And in fact, when you read, I mean, that's why, I mean, there's, Smith is a complicated person in this story because there are significant passages and significant questions about how much regulation he was actually in favor of. But go ahead, yeah.
Because if you ask Smith, what is a monopoly? The Smith idea of monopoly was a government-granted charter, like a government-granted monopoly. Like Smith wrote before the time of scale and mergers where one could produce at lower cost, and so you wouldn't have conditions where there was a tendency towards equilibrium.
Okay.
So for Smith, markets would equilibrate because there was no other market paradigm.
What do you mean? What do you mean markets would equilibrate?
So the idea of natural order is that if you leave the market alone, it tends toward equilibrium.
Right. But nobody really believes that, right?
Yeah, because at the time Smith wrote, he wrote about perfect competition with homogeneous commodities. And he didn't see the cases where you had factories producing at large amounts of scale, such that if you left it alone, you would tend towards monopoly. If you ask Judge Posner, do all markets self-equilibrate, he'll say no, there is.
Right.
Intervention.
Right. Yeah, no, that's right. That's right. But the point is, and therefore, right, and therefore it's all in what regulatory mechanism are you proposing for me, right? And it's all in what is the standard for antitrust intervention, right? It's all in those mechanisms. It's not as if you're going... The notion that liberty, in some sense, has something to do with this is the part that's problematic, right? Yes?
But, I mean, you can envision a situation, right, where it is the actual amount of regulation in place or the regulation's burdensomeness rather than which particular regulations are in place that's relevant. I mean, so that you could describe a market as overregulated because people were reluctant to enter enter the market because of the amount and burdensomeness of regulations in the aggregate.
You could describe a market where, because of the forms of market organization, there is less entrance into the market. Yes.
I mean, so
That might or might not be good. It depends on the distributional consequences, right?
So in that sense,
I mean, in other words, like, having more is not necessarily what we want. In fact, that's definitely not what the Chicago Board of Trade wants, right? Because they want the seat at the Chicago Board of Trade to cost $4,000. They don't want it to cost 25 cents. So it's limited. It's regulatory mechanisms that limit the amount of people who can actually be on the floor, right? The question is not, are not enough people coming into the market? The question is, what are the distributional consequences of having this particular way? But it's not a question of more or too much or too less, no? It's a question of which regulatory mechanisms you would have in place. No?
well, I think there are two senses in which you can use the free market, regulated market terminology. Well, one would be that just your freedom of action within a market is coterminous with the regulations that are in place to prescribe certain actions within that market, right? So, I mean, my freedom to participate in the bid at the Chicago Board of Trade is coterminous with whatever rules and regulations they put in place about that.
And related to other people's abilities to or not to, right?
Right. So, I mean, it seems like there's a sense in which instead of using them as categories of a free market and a regulated market, I mean, you can say there's a continuum between a completely anarchistic.
I want to argue that it's not even a continuum, which I realize is even further or even harder to defend, right? But no, I want to argue that it's not even a continuum. It's not even a continuum. That essentially, if you give me a description, of what we consider to be a free market, I will unearth for you all of the regulatory mechanisms that are at play in that space. They may not all come from the same source. They may not all be government-based regulatory mechanisms, but they're going to be perfectly identifiable cluster of equally regulated space, whether it's in part by the Pitt Committee, which is a kind of quasi-private organization, right? Because the Chicago Board of Trade itself is quasi-public, it's actually private, right? Or government interventions, but that the difference between, say, that we tend to identify only the government regulatory mechanisms as being affecting our liberty in some way, right? But in fact, all of the other regulatory mechanisms are there. We're in a bath of regulatory mechanisms, some of which are governmental, other of which are private, other of which are norm-based, other of which are chartered by the state, etc. And that those regulatory mechanisms allocate resources, redistribute wealth, and we need to understand what they are, right? And it's not a question of a spectrum of more regulation or less regulation. Although, if you limit yourself exclusively to government intervention, yes. If you limit yourself exclusively to government intervention, if you have no notion of delegated powers, if you have no notion of a kind of act omission kind of continuity, right? If you have no notion that the Chicago Board of Trade is regulated by the Chicago Board of Trade under a charter that's given by the state of Illinois, right? Now, therefore, what? The state of Illinois isn't doing anything here? I mean, that's a very simplistic way of thinking about it, it seems to me. The state of Illinois could decide to regulate. The state of Illinois could say this is a public utility. The state of Illinois could say this is our thing. And instead they say, no, we're going to allow for forms of self-regulation from this self-regulatory institution, which in effect is just giving the regulatory power to another human organization, I think you'd have to be. I think you have to be somewhat. Don't know. I don't know what the right term is. I think you have to be blinking reality not to see that the space is entirely regulated and that it's simply different regulatory mechanisms and different centers of power that are doing the regulation, right? Don't know. One more question. Yes?
Is the entire scope of regulation questions working out into monitoring and marshalling costs and moving the line between them so that sometimes there should be you're willing to allocate more resources to monitoring and marshalling? To what extent can the difference between the U.S. way of looking at it and the French way of looking at it be attributed to the idea that in France there's this idea of absolute monarchy and that decision to place more in monitoring versus marshalling came from above, and in the U.S. there's this idea of self-regulation and building upon it in the sense that the cells will collect together and decide how to allocate monitors.
Right. Totally. In other words, we're going from a very centralized system, right? This was all central governmental power, right? That went from Louis XV to the lieutenant of police, right? So it was governed by a federal authority in a very centralized way in a period of centralization, of political centralization and political regulation, versus a very different system, right? Which doesn't have the, you know, it's not even, it's a federated, right? It's a state government regulatory mechanisms. Now, but of course, today it's come to the point where it's layered with lots of all kinds of different interventions, right? So you have the U.S. Attorney's Office gets involved. That's the federal government. The federal courts that supervise commodity trades get involved. All of the in-house commissions get involved, et cetera. So yeah, that's right. But the point is that that doesn't tell us whether we like the outcomes or not, right? It gives us an idea that, yes, you've got a different system of structuration of market organization, but it doesn't tell us anything about whether we like the outcomes or not. And what we need to do is see what the outcomes are, right? Okay, I said one more question, but Fabienne, I saw you had your hand up just to, yeah.
This may seem a little anachronistic, but I think it's interesting. You're going to try to unearth the history of this discourse about freedom versus regulation. And I'm saying this discourse is fundamentally tied to what we call class interest, right? Or a certain understanding of how one represents what freedom is to further certain ends of a social group, or in other words, for example, yes, we're all free to sell our time to someone else, or our commodities that we possess without and the market we can set.
Right.
We can
right.
Free
right.
Situation.
Right.
Right. But I'm curious, and I don't know how you address this, right? And personally, I think this is a little bit misleading and doesn't quite capture it. But so, for example, in the famous passage, right, in Volume 1 of Catholic, Marx says, on the surface, the seller of labor power is on equal terms with the factory owner, right?
Right.
And they're there in the light of freedom, equality, and benefit.
Right.
But when you actually go into the hidden mode of production, you'll see how profits really work.
Right.
That the very quality of being able to sell or not sell is completely undermined. It's ideological.
Right. And so the point is that the negotiation relations, this is actually Robert Hale, right, for those of you in crim law, right? The relationships of negotiations, the power relationships in negotiation are all defined by a regulatory structure that involves in part who has property interests and who doesn't, right? And that those are all in some sense equally coercive in the sense that they are created by the state and imposed on people. And so I think the reasoning is right. The only thing that I would want to do is that I think that when you start, my rejection of notions of categories, I think, would then also apply to notions of class, simply because I'm not sure how we would be constructing these categories themselves, okay? And so I really would want to do a more kind of individualized outcome. It's like, I really want to know who is benefiting and who is not benefiting. All right. Thank you very much.